Hi, welcome. I'm Kelly Longtin from Kelly Longtin Law, and welcome to our YouTube channel. Today I'm going to talk to you about qualified domestic trust. So basically how you can take a jump start to protect your non-citizen spouse. Now, married couples love each other and they typically want what's best for each other. Establishing a comprehensive estate plan is one way to provide the best for each other. Not only does an estate plan protect you when you're unable to care for yourself during your lifetime, but it also protects your hard earned money and property after your death for those that you love. When your spouse is not a U.S. citizen, it becomes even more crucial to have the proper estate planning tools, especially if you have a high net worth. One of the benefits associated with marriage in the United States is the unlimited marital deduction. With this tool, a person can transfer unlimited money and property to their spouse during their lifetime and upon their death without estate and gift taxes being owed. One rationale for this deduction is that married couples are assumed to rely on their joint accounts and property to fund their needs and wants during their marriage and to support the survivor. The IRS is not concerned about assessing estate tax to what is left to the surviving spouse, because whatever is left over will usually be subject to estate tax at the surviving spouse's death. However, the unlimited marital deduction's favorable tax treatment is usually only available if the surviving spouse is a U.S. citizen. For non-citizen surviving spouses, additional planning must be done to take advantage of the marital deduction estate tax benefits. So why can't a non-citizen spouse use the marital deduction? When a surviving spouse is not a citizen, the IRS is concerned that collecting the estate tax owed on the first spouse's money and property may be more difficult when the surviving spouse dies. Because the surviving spouse is not a citizen, it is possible that they will return to their country of citizenship, which makes it impossible for the IRS to collect the estate tax. Qualified domestic trust could be the answer. The Qualified Domestic Trust, or QDOT, balances the IRS interest in collecting estate tax in the public policy argument against requiring a surviving spouse to pay substantial estate taxes and be left with less than what they need to survive. So, what is a qualified domestic trust? A QDOT is a trust created by the U.S. citizen spouse during their lifetime to hold accounts and property on behalf of the non citizen spouse. Alternatively, a QDOT can be made by the non citizen spouse by irrevocably assigning the accounts and property they received from their deceased U.S. citizen spouse to the QDOT before the deceased spouse's estate tax return is due. The accounts and property passing to a QDOT can qualify for the marital deduction with either option. However, the estate tax is deferred, not eliminated. So let's talk about how a QDOT works. While the non-citizen surviving spouse lives, they will receive income from the trust. This income will not be subject to estate tax, but will be subject to income tax. If any principal distributions are made from the QDOT to the surviving spouse, then the Internal Revenue Code 2056A estate tax will be owed on that distribution. However, an exception may be made if the distribution is being made because of a hardship. When the non-citizen spouse passes away, the money and property remaining in the QDOT will be subject to the estate tax. That is why we say that a QDOT does not eliminate the estate tax. It just defers it until the non-citizen surviving spouse passes away. Once the taxes are paid and other administrative tasks are completed, the remainder of the trust is distributed to the named beneficiaries. For the QDOT to be legally effective, the following requirements have to be met. Accounts and property given to the non-citizen spouse at the citizen spouse's death must be transferred to the QDOT before the deadline to file the decedent's estate tax return. The trustee must elect the trust as a QDOT on a timely filed estate tax return. U.S. state laws or the laws of the District of Columbia must govern the trust administration. The trust must qualify as an ordinary trust under the Treasury regulations. The trust must include terms that qualify the trust as a power of appointment trust, a qualified terminal interest property trust, qualified charitable remainder trust, or an estate trust if created by the U.S. citizen spouse. At least one trustee must be a U.S. citizen or a U.S. corporation. The trustee must have the right to withhold estate tax in making distributions of principal to the surviving spouse, and when the balance of the QDOT is distributed at the non-citizen surviving spouse's death. Additional requirements must be met depending on the overall value of the accounts and property that are in the trust. So what happens if the non-citizen surviving spouse does in fact become a U.S. citizen? The surviving spouse may choose to become a U.S. citizen. This could be because of the administrative burdens of a QDOT or a firmly held desire to change their citizenship status. If a change of citizenship occurs, the surviving spouse may become eligible to use the marital deduction without using the QDOT. If the surviving spouse becomes a U.S. citizen before the deceased spouse's estate tax return is filed and stays a U.S. resident after the deceased spouse's death, then the deceased spouse's estate will be eligible to use the marital deduction for any assets transferred to the now citizen spouse. If the surviving spouse becomes a U.S. citizen after the QDOT was created and stays a U.S. resident after their deceased spouse's death, and either does not receive any principal distributions from the trust or treats the trust distributions as taxable gifts, then the QDOT can be terminated, and the remaining balance of the assets in the trust can be eligible for the marital deduction. So in conclusion, we know that no one likes to think about death and dying. Most people do not want to pay more taxes than is required. You need to plan proactively to minimize tax consequences upon your death. Now, you want to reach out to your local qualified estate planning attorney that practices in the state in which you reside to assist you and your spouse in creating a plan to protect your futures and each other. So I hope you found this helpful if you have a non-citizen spouse or if you are the non-citizen spouse. I'm Kelly Longtin from Kelly Longtin Law, and please like and subscribe our page below in order to learn more about estate planning and some options that may be beneficial to you and your family.